Good afternoon. I'm very pleased to be able to moderate this panel entitled PIL and DLT, What Challenges Lie Ahead. We would like to thank the HCCH for this kind invitation and begin today's discussion as a sort of Q&A with our comparative law experts on this panel. Burcu Yüksel Ripley of the University of Aberdeen, Florian Heindler of Sigmund Freud University, Vienna, Amy Held of the University of Vienna, and Tobias Lutzi of the University of Augsburg. Legal relationships arising out of and in connection with DLT are international in the overwhelming majority of cases. This is caused by the operating principles and applications of DLT in an environment in which people or entities communicate and transact peer-to-peer on the internet without relying on central bodies or intermediaries. Private international law rules connect a legal situation with a particular state when that legal situation has an international element. And while conventional PIL rules may still apply to transactions in this environment, there are several new PIL issues arising in this context. In their work, Yüksel, Ripley, and Heindler, Held, as well as Lutzi, address the issue of applicable law as it relates to crypto assets, broadly defined as, quote, cryptographically secured digital representations of value which can be transferred, stored, or traded electronically, unquote, using distributed ledger technology or a similar technology. Our Q&A with the experts will take approximately 30 minutes, at which point we will reflect on a final policy question before opening the floor to questions from our viewers. Our first more general questions are addressed to Burcu Yüksel Ripley and Florian Heindler. Given that DLT has a truly global structure, how should we determine whether or not a DLT-based transaction involves a foreign element?
Thanks very much, Shaheeza. And I think it's an important question, although sometimes it does not get much attention. It's actually the very first question we face in private international law, and it is that foreign element that transaction, situation, relationship involves, which triggers a private international law analysis. And in private international law, a foreign element is generally understood as an element that connects a relationship, situation, or transaction to more than one legal system. So if we apply this understanding directly to DLT-based systems, this would mean that all transactions within DLT-based system involve a foreign element, because these systems have global structures with no actual borders, and they have participants from all over the world. However, this is probably neither feasible nor desirable from the perspective of private international law. Let's say that I'm in Scotland and transferring some cryptocurrencies to another person who is also in Scotland. But this transaction will be taking place in a given cryptocurrency system. But in the end, this is a transfer between two people located in Scotland. So it might be perhaps a better approach to consider this transaction as a transaction connected to only one legal system, which is the Scottish legal system with no foreign element. So in analyzing whether a DLT-based transaction involves a foreign element or not, I think rather than labeling all transactions in DLT systems as international, we could perhaps consider using a criterion based on the location of the relevant parties. If they are located in different countries, this is then an international transaction or a transaction with a foreign element. And then this would be followed by a private international law analysis.
Thank you. What are the potential and limitations of party autonomy in determining the law applicable to DLT systems and applications such as crypto assets?
As we know, party autonomy is a well-established principle in private international law, and it's widely accepted worldwide by a large number of states, particularly in relation to contractual relationships. And in the context of applicable law, this principle allows parties to agree on the law governing, the law applicable to their relationship or transaction. But there are certain challenges in the application or operation of party autonomy in determining the law applicable to DLT systems and application, which has been also identified by the Hague Conference in its work on PIL implications of a digital economy. So there are, I think, two dimensions here. One of them is the technical or technological dimension, and the other one is the legal dimension. From a technical or technological point of view, the main question here is that whether it's technically possible to incorporate or include a choice of law into consensus rules or protocols in DLT-based systems. So this is maybe for a question for computing scientists, but it appears that technology is advanced enough to incorporate or write choice of laws in this system of system rules or protocols. So we may come across such choices probably in permissioned private systems. From a legal point of view, if there's a choice of law as such, this choice should be binding on all system participants because they have agreed to system rules, which includes the choice of law, in order to be able to participate in the system. And they also agreed to comply with these rules once they have participated in the system. So such a choice should be considered effective before forums which accept the principle of party autonomy. However, for permissionless public systems such as Bitcoin, I think the situation would be a bit different because there is pseudonymity in these systems. So true identities of participants are not disclosed or known. The ledger is updated by a consensus of special participants. In case of Bitcoin, there are miners who informally work in a peer-to-peer manner as transaction verifiers around the world with no central coordination. So in terms of choice of law, I think it does not seem very likely under such a system structure for all system participants who are pseudonymous and located in all over the world to agree upon an applicable law and also upon the same applicable law. Party autonomy can probably only work at transactional level in permissionless systems, and but we have further questions in relation to that as well. Now, who are the parties whose agreement is needed for a choice of law agreement? For example, in a Bitcoin transfer, is it only the payer and the payee whose agreement is needed on the applicable law? If we say yes, choice of law can function effectively and the given transfer can be governed by the law chosen by the payer and the payee. But in addition to them, if minors involved in a given transfer would be considered as parties to the transfer, whose agreement is also needed for a choice of law, I think it would be highly unlikely for all these parties to agree upon an applicable law, not only before a transfer take place because of the structure of permissionless DLT systems and also the element of pseudonymity, but also after a dispute arises, given that it would be highly unlikely that all of these parties will be brought before the same court. So I think the potential and limitations of party autonomy in determining the law applicable to DLT and systems and applications would probably depend on the technicalities of the system, type of the system, and the interpretation of elements of choice of law, such as parties in a given forum in the context of DLT.
Thank you. And in the absence of a choice of law, what could be a suitable objective connecting factor for cross-border disputes relating to DLT systems and applications, such as crypto assets? Or which rules applied to other non-corporeal assets could be adapted?
Thank you very much for the question, Shaheeza. Indeed, in our paper, we have advocated an adaptation of pre-existing connecting factors in the different fields of private international law. We hope that everyone, or at least many other authors, can agree that DLT systems and applications are used for a wide range of questions falling under various traditional categories of private law and categories of private international law. Apart from tort and property law, where we have a special focus of Amy and Tobias today, we see DLT issues arising in insolvency law, in succession law, in contract, in intellectual property, and many more. And we have heard many examples, many more examples during the last days too in this conference. So as far as these categories are concerned, we already have particular rules, legal instruments, especially legal instruments of the HCCH in place with their specific connecting factors. And in our paper to this compendium of Professor Bonomi and Professor Matthias Lehmann, we have proposed not to get rid of these categories at all when it comes to DLT systems and applications, but to adapt the existing connecting factors and to apply these rules and instruments, because if we have an insolvency case involving a DLT application or a crypto asset based on a DLT system, we still want to have the insolvency rules applied and not to have a special instrument catching all questions as soon as a DLT system or a DLT application is involved. This means that the rules, of course, need to be amended by legislative action, or if possible by the judiciary. We have to focus, we have to face the situation that it is very difficult to amend a HCCH convention, for instance. The same applies to other instruments, e.g. in European law, and therefore, and in addition, we don't know what the future will bring. So as long as we have a technology neutral approach in the instrument, in the convention, this is of course much more favorable, because it can be developed by judiciary, by interpretation, instead of having a burdensome amendment procedure. However, one central issue, I think, appears in many legal situations as we call it in the private international law discourse, as an incidental question. I think in many cases we come back to the situs of a so-called electronic asset attributed to a person by a DLT system or application. We are focusing on third-party effects of transactions on the proprietary situation of the asset, so to say. And as far as HCCH conventions are concerned, we don't have an instrument in place regarding that issue. I'm sure that Amy shortly will highlight more about the connecting factors that can be thought about. But here I think we can have a core instrument which when incidental questions point at these issues, which can be in place. The term attributable electronic asset, by the way, is taken from the work of the Uniform Law Commission on questions of substantive law in the United States, and it is a functional term. And what I want to highlight in my intervention as well is that we would like to see the functional terms, the neutral, technology neutral terms, also in the work of the HCCH, and we see also from what has been published so far that it is fortunately also going into this direction. Thank you very much.
Thank you. Many thanks to Burcu and Florian for your responses. We will have time for questions from the audience after we hear from our next two experts, starting with Amy Held. In her work, Held argues that while there have recently been proposals for ascribing to crypto assets and/or decentralized ledgers an artificial situs to apply the situs principle, it may be time to abandon legal categories developed for inherently territorial things and instead develop new categories and rules to accommodate crypto and other similarly omni-territorial assets. Amy, in your work, you explain how the situs principle has maintained a unique position in private international law as the primary connecting factor in cross-border proprietary claims. When might situs matter with respect to crypto assets?
Thanks, Shaheeza. So yes, there is a remarkable degree of consensus regarding situs in private international law that cuts across many different jurisdictions. This rather unique position has aptly, I think, been described as the situs monopoly. But I think in light of this position, I think it's really important to define when the situs principle is actually engaged at all. So first, we're talking about disputes that arise under the general private law of property. So we're not talking about special regimes such as those we have for IP or shares, but claims based on rights you're likely to find in, say, a civil code or which have their origin in common law principles. And so second, whilst we often talk about property rights, or property in terms of substantive rights such as ownership or security, I actually think it's more helpful for our purposes to conceptualize property disputes in a slightly different way. And this would be thinking about property disputes where the paradigm case is that where the defendant and claimant are complete strangers. And the only thing that's connecting them is the simple fact that the defendant happens to have something that the claimant asserts is his. And this kind of scenario, I think, is quite plausible in the cryptosphere, given how easy it is, at least technologically speaking, to trace crypto assets, using services like chain analysis, etc. So say I've been hacked and the hackers deprived me of my Bitcoin and then transferred them onto a third party. In many cases, it might actually be easier for me and much faster to trace the Bitcoin to that third party rather than find some hacker unknown for a claim in tort. And obviously, if I want the asset itself back rather than compensation for loss, I would have to go for that third party. And so if I do choose to go for this third party, simply as the person who happens now to have the asset I say is mine, I have to sue in property. And situs exerts a monopoly over the present rules of private international law for general property disputes such as this.
Thank you. So why do omni-territorial phenomena such as crypto assets and decentralized ledgers seem to pose such a problem for the situs principle?
Okay, so I think to answer that, it's probably worth going back to the underlying rationale of the situs principle to begin with. In cases where the only thing connecting the parties is something that happens to be in the hands of the defendant, it's actually quite easy to see why the thing and its location is taken as the relevant connecting factor. There isn't actually very much else. But this also makes quite logical sense for things like land, which don't tend to move very much. And so the situs principle in this kind of circumstance lends itself to a very highly predictable rule. It makes slightly less sense for tangible movables because where they are can and does often change. But I think in most cases, sort of the situs principle sort of works most of the time. Now, with intangible things, this logic is increasingly challenged because, intangible things can't be said to exist anywhere at all. And this particular problem actually predates the omni-territorial asset. It's inherent in things like the contract debt and intermediated securities. For these particular types of assets, however, what we see is that the primacy of the situs principle in law has generally prevailed over the intangible nature of these things in fact, by means of a little legal fiction. the approach of the law is to give these things an artificial situs for the purpose of the law, like the habitual residence of the debtor or the place of the relevant intermediary account. So we establish this artificial situs, and then we continue to apply the situs principle in a slightly artificial way. So all crypto assets and decentralized ledgers do is take this essential problem one step further, in that it's much more difficult to pin down omni-territorial things down to a single place in the same way. I won't go over the technical features of these things, but I think it suffices to say that these assets literally exist everywhere and nowhere at the same time. So the real problem isn't that we can't connect them to a single jurisdiction. It's more that they are too connected to every jurisdiction at the same time. So how then do we localize them to a single legal system?
Okay, so if I understand correctly, your view is that in light of these problems, the situs of a crypto asset may not matter in most cross-border disputes. Could you explain why?
Yes, that's actually right. And there are three main reasons for this view. First, I think it's really, really important to remember that just because a dispute concerns a crypto asset, or a claimant even alleges that they're entitled to a crypto asset, and this doesn't necessarily mean that the particular issue in the dispute will actually be characterized as proprietary. And again, as most people here will know, the commercial and technical realities of these phenomena are that they involve a vast network of legal actors, your exchanges, your wallet custodians, etc. And these actors deal with each other in ways that give rise to clear contractual or tortious relationships. And another thing to bear in mind on maybe a slightly more technical legal basis is just because a dispute is prima facie to do with ownership, the precise legal issue at hand might not necessarily be a proprietary issue. And a great example, just to mention in passing, is the Webb case in the CJU. So all in all, I think it would actually be a very rare case where a claimant actually has no one they can sue in contract or in tort and sort of has no choice but to resort to a property claim against a complete stranger. I think Tobias will probably agree with me here that characterization in contract or tort doesn't necessarily solve the localization issue. But I personally think that the emphasis here on the parties' relationship rather than the thing itself makes the localization analysis just slightly easier in that there are a few more connecting factors to choose from. That's not to say that I think a property issue will sort of never arise in relation to these things, and I think this is most likely to be the case where a network is unpermissioned and the asset is held directly. So paradigm example might be a direct holding of Bitcoin. But even in these kinds of cases, I think there are two further reasons why the situs principle might not necessarily be engaged. And the first is that there is still an overwhelming lack of authority regarding the legal treatment of these things as a matter of substantive property law. The basic question is, are they recognized under the general law of private property such that the situs principle is prima facie engaged? Or do they derive their proprietary character from another legal basis? And so I mentioned the IP and shares earlier, and I actually think they're really, really useful examples to illustrate this distinction. So IP and shares are both considered the object or capable of being the object of proprietary rights in the traditional sense that you can alienate them, they have third-party effects, etc. And in many legal systems, they are often classified, say, as personal property or movables. But at the same time, they're widely recognized as being outside the general rules of property due to their distinct legal mode of existence. And so these kinds of things are instead subject to their own legal frameworks, which often include their own unique private international law provisions. And which is why for IPN shares, we don't generally need to have recourse to the Citus principle at all. Now, obviously, there's as yet no distinct regime for crypto assets comparable to those applicable to IP or shares, but I do think this has to be kept in mind as a potential possibility in the future, especially as there are many reasons why IP and shares might be considered better precedents for conceptualizing crypto assets and decentralized ledgers as things in substantive law. Now, again, this doesn't necessarily mean that we get rid of the localization issue, but the specific legal treatment under the law, such as designation as a registered asset, may well give rise to a wider range of connecting factors that refer to their legal mode of existence rather than their empirical mode of existence as this sort of wholly decentralized thing, as a matter of fact. Second, I think even if the general rules for property apply under PIL systems, I think it's really important to remember that no rule of private international law is actually absolute. And this is particularly important to recognize in the sphere of property law with its Citus monopoly. I think in property law, there tends to be this perception that Citus is some sacrosanct principle that sort of applies without distinction in all property matters. And I think this perception is very unhelpful because yes, Citus is the undisputed connecting factor for immovable property. And in this context, I think there's a very good reason for this. But what's often overlooked is that the application of the Citus principle is far more contentious for tangible movables. And a key factor here is that it doesn't stay put in one place forever like land. And as such, property claims to personal movables traditionally use other connecting factors. Under English law, Citus has only come to prevail for intangibles in the last 60 or 70 years or so, and not without significant controversy. And so from this, I don't think the modern debate in relation to omni-territorial assets is helped by the fact that the modern rules for other intangibles have been so unable to resist the sort of spell of the Citus monopoly. Because if we unpack the analysis underpinning an artificial Citus, all we're really doing is finding the most appropriate connecting factor to arrive at the law or jurisdiction of a certain legal system. And I don't think it's helpful to elevate what is simply another connecting factor to the status of artificial Citus just because the dispute is proprietary. All we are doing is the same as we often do in contract and tort in the final analysis. We're just finding the most appropriate connective factor to identify the most appropriate form in applicable law. Obviously, it's a little bit more difficult for omni-territorial things, but I don't think it's impossible. I do have some provisional views on alternative connecting factors under the general law and how this might tie in with potential special regimes, but I think in the interest of time, it might be better left for the discussion.
Okay, well, thank you. A big thank you to Amy for these insights. If you're watching and have questions, please write them down. We'll now turn to our final expert, Tobias Lutzi, before we open the floor to questions. So in his work, Lutzi addresses torts relating to crypto assets. He agrees with Held that there's a significant challenge in the absence of geographical connecting factors for these omni-territorial assets. As far as the law of tort is concerned, this is exacerbated, of course, by the absence of any pre-existing legal relationship. Lutzi explains that PIL struggles to accommodate both delocalized torts and torts involving more than two parties, although he does believe that it is ultimately able to do so. So, Tobias, in your work, you explain the difficulties of determining the locus damni. Would an open textured closest connection test or the so-called lex cryptographica be a viable alternative to the locus damni?
Yeah, so thank you very much. Indeed, I believe that the problem for the private international law of tort is structurally very similar to what Amy described in relation to the Citus principle in the law of property. Because in both cases, we have a situation where two parties are not previously connected, and we try to solve the problem of finding the applicable law to their dispute by relying on a purely geographical connecting factor. In this case, in the case of tort, it's the locus damni, the place of the damage, which is the most established connecting factor, and which assumes that the tort can be pinned down to a location by simply finding the place where it caused the initial damage. Again, very much in line with what Amy said, I think this works reasonably well for many types of torts. So wherever there is some kind of physical asset, for instance, a key or wallet stored on a physical device, we don't have a problem for private international law for the locus damni rule, because those torts can be easily localized. But as soon as the tort consists in tricking or coercing someone into transferring virtual assets that are only stored digitally, then we run into the same problem that we heard about before. And then the only solution appears to consist in artificially ascribing a location to these assets. This is what courts have been doing in online cases for years, for decades actually, trying to localize the place of the damage. And even in traditional internet cases like defamation and so on, or IP infringements, this has worked poorly, and it has created a strong tendency for courts to eventually simply either fragmentize the applicable law or simply apply the law of the domicile of the victim. But my problem at a general level with that approach is that this is almost impossible to foresee in many cases for the tortfeasor, who may have no concept, no idea who the alleged victim of the tort is located. So already in the usual internet scenario, this is a problem, and it becomes almost absurd if we think about permissionless crypto networks, where it's often part of the design that they are not, in any sense of the word, localized in a given place, but where the actual design choice is to make them, to distribute them as far as possible, to make sure they cannot be tampered with, because they are stored in many places at once and they can only be altered through a purely technological way, but not through any kind of physical interaction. So now, as you're saying, there are, of course, alternatives to the exercise of localizing the damage in such a scenario. And the most radical proposition indeed would be to apply the so-called lex cryptographica, which is very, very similar to what we were discussing in the 90s and early 2000s of a lex informatica, which both assume that these networks are essentially self-governing, and therefore we don't need to apply state law at all. We simply apply the law of the network, or the law of the internet. And actually, the argument is probably stronger even when we think about crypto networks, because of the importance that the code has there, and the way in which consensus rules can be enforced one-to-one via the code. So there is actually an argument, an additional argument maybe for that. But of course, this approach has not at all become reality outside of very niche parts of the scholarship, for many reasons. One of them being that usually those rules are simply not comprehensive. They don't have any rules for liability, and especially they don't have rules for liability of outsiders. So if anything, if you even find rules within a network of that kind, those would usually be rules on transactions between members of the network, but not for liability of third parties. And even if you would be able to find such rules, how can we legitimately apply those rules to someone who is outside of the network? This is an approach. There are other reasons as well, but this is simply not something that's realistically feasible. And then the other alternative would, of course, be just try to find an alternative closest connection. But the thing is, this sounds great on paper, but it doesn't say anything. The question would then still be, what is the closest connection? And if it's not the damage, then we need something else, and we need to define the closest. connection. And this brings me actually to the proper answer to your question in a very unnecessarily long way. That we need to, I think, move away from the exercise of trying to localize the tort, and we need to look at the party's location. And this, of course, resonates with what the previous speaker said, that if the tort or the object of the dispute is simply intangible, then maybe the parties involved in the dispute are the better approach.
Thank you. Thank you for that answer. In your work, you suggest that it may be best to apply the law that best reflects the party's expectations, so in line with what you just said, rather than to try to localize assets that are inherently delocalized. How might this be achieved in your view?
Yes, so the criterion of legitimate expectations is, of course, very old, and in every textbook on PIL, you will find the respect of legitimate party expectations as one of the cornerstones of the whole conflict of laws exercise. It's the raison d'être of the discipline in a way that we need to honor as much as we can the expectations of the parties. And as any lawsuit, as I said, kind of involves at least two parties, I think this is a good starting point. The question, of course, is whose expectations do we give preference to? And in my view, the default rule should be that we look at the alleged tortfeasor, because they may very legitimately expect to be judged under the law of their own domicile or residence. I don't think there's any real expectation in most cases to be judged by a law from the other side of the globe purely by the accident that the person who suffers a loss from whatever you've allegedly done lives very far away. And of course, I realize that the immediate counter argument to that is that the victim nonetheless may have an equally legitimate expectation to be protected under their own law. And I think there must be certainly exceptions from looking at the tortfeasor, which would then bring us to look at what the alleged victim expects. But these exceptions need to be justified by some kind of additional factor, such as a disparity in power or the fact that a tort was deliberately targeted at certain jurisdictions. In those cases, I think it would be more legitimate to look at the victim. But in any case, I think what is most important really is that we start talking about the relationship between the parties and just give up the fruitless exercise of looking at the tort itself.
Thank you. So do you have any policy recommendations in this regard?
Well, so this is part of my policy recommendation, but of course the question is how do we realize this? How do we put this in practice? And so my honest opinion is that we need two steps, and the first step is to simply abolish the lex loci damni principle, either altogether or at least for a certain set of cases. I think actually this is something that Amy mentioned also, that we need to ask for the rationale of a rule, and the rationale of the Sinus rule is that what connects the two parties is the object of the dispute, and then we go from there. But if the object cannot be found, then this does not help us anymore. And similarly, I think in tort cases for decades, it was always kind of possible to identify the place of the damage, and then you had a good starting point for a number of reasons. But in more and more cases, we don't have that, and that's why I think the rule needs to be reconsidered, at least in all cases where there is no sensible place of the damage. And then the second step would be to find an alternative to that criterion, which in my view could be as simple as the locus actus, but we could also think about more sophisticated rules or certain combinations of different connecting factors depending on the situation. But all of that kind of is the second step after having abolished the lex loci damni approach. And as far as the formalities are concerned, this could, of course, theoretically be the object of a Hague Convention. I don't think there's any prospect of adopting a convention purely for cyber torts, but it may be a useful protocol or annex to a convention that at its core deals with transactions within a network or using a specific type of technology. And then the annex to it could be some PIL rules on torts connected to those transactions.
Wonderful, thank you very much. I'd like now to invite your colleagues to reflect on this same question and perhaps a few more. Should traditional connecting factors be abolished or adapted for cases involving DLT? What would be suitable alternatives? Do these alternatives share any common features with other areas such as contract, tort, IP, company law, negotiable instruments? And what would an international PIL instrument look like in formal terms? We look forward to hearing your views on these and any other questions that come up in the next, I would say, less than 15 minutes, 12 minutes. So the floor is yours. Perhaps Burcu could start?
Yeah, would be happy to start maybe with some broader thoughts and points on your questions, Shaheeza. I think we have some existing tools which would work in DLT context that we can utilize. For certain situations or questions, these existing tools may not provide satisfactory results, and development of internationally agreed conflict of law rules, I think, might prove useful for them. And when developing these rules, I think it's important to consider that there is a need for a sufficient degree of flexibility, along with legal foreseeability and certainty in digital economy to facilitate diverse and fast-evolving markets with technology. And maybe before passing on to Florian for his views, I could just add that I think the past work of the Hague Conference from 1980s, 1990s on technology-related areas includes some very useful insights. Those were considered conflict of laws occasioned by trans-frontier data flows, commercial law problems arising from the utilization of electronic processes, as well as the problems of the law applicable to international credit transfers and electronic funds transfers. And I think it's all very useful for the discussions we are having today on digital economy, 30, 40 years later after this work. So I think it also shows how innovative and forward-thinking the Hague Conference is, which is very commendable.
Yeah, if we have no additional question, let me please highlight that I also believe that we can remain within our law framework, attributing questions to tort, to contract, to property issues. That this the fact that we have no physical location, that we have no physical asset in place, does not render our statutist choice of law framework inapplicable. I am very much in favor of this. But of course, whenever we develop further the system, we have a chance to refine it and to develop it in a progressive manner. And when Tobias said that the tort issues could be an annex to a transaction-based instrument, we of course could also have reflections on whether we have to distinguish, or how we should distinguish, let's say, contractual and non-contractual obligations, for instance, in this area, because we have parties who are not connected by a contract in our traditional understanding, and maybe here we could align some questions in the law of obligations. So that was a spontaneous thought when I heard you thinking about having an annex for tort issues. And one final thought, maybe, because we have, of course, some experience with non-physical assets in choice of law. As it was mentioned, we have IP rights, we have intermediated securities, and we have some connecting factors for these situations too. What I just want to mention is that they are not naturally apt for crypto assets or attributable electronic assets in general, because if I think about lex fori protectionis, which we have in IP, this is a political matter, this is a political choice, but I think we would do no favor to, or we will not steer the technological and economic progress of DLT systems if we apply disconnecting factors to them. This is what I already mentioned, I think, in 2019 in a paper, and there are many more authors who are critical. We have experience, we can find connecting factors, but of course we have to be very careful. Maybe a last spontaneous thought. What I found very attractive were the suggestions of Matthias Lehmann on Tuesday, referring to custodians in the domain of crypto assets, and I had a similar thought in our discussion when we prepared today's meeting, focusing on gatekeepers, because to some extent gatekeepers will be introduced by the legislators. Also, this is not in the interest of I think some parts of the crypto assets community, and they can serve maybe as a starting point to identify suitable connecting factors, I think, in a way as it has been described by Matthias Lehmann. So many different aspects for discussion.
Sorry to cut in here. I'm not sure if you can see the messages, the questions that are being sent from our audience. If you click on conversation at the top, that will help you. There's a first question. Is there a clear enough public interest factor in digital assets as an emerging and critical area of commercial activity? There's a second question that's directed at Burcu, Ripley. Unidroit, in their draft principles, advocate in the first instance the law specified expressly in the asset or system. Anyone dealing, disposing, or dealing with the asset is said to consent to the law, putting aside how frequently such a choice would be made. This seems to address the issues you mentioned with regard to party autonomy. What are your thoughts on this approach to party autonomy? And I'll let you think while I read the last question. The last question is about the part of the conference which has been discussed as liability. Can party liability be considered by using Ethereum smart contracts? Okay. I don't know if any of these questions can be addressed at this point. If anyone wants to take any of these questions at this point, or if we could.
I could answer the one that's directed to me, Shaheeza, if that's okay.
Okay, sure, please.
Yeah, so thanks very much for this question, and I agree with that approach. I think it's a very practical and functional approach in the context of DLT systems or its applications to have such principle referring to the law specified expressed in the asset or system, and then parties are deemed to consent to those the choice of law in that respect. I think maybe the issue is that it would work well in permission systems, and it would also address some of the issues that might arise in the context of party autonomy. And maybe the issue in that context, in context of permission system, the issue might be that, you know, if the parties, the relevant parties have already a choice of law clause in the underlying relationship, how that would interact with that, the law governing the system in terms of the choice of law. That would be the, I think, maybe the question that needs a bit more consideration. But on the other hand, for permissionless systems, I don't think that it would solve the problem, because the permissionless systems, in their very nature, come with the idea that the code is law or they are self-regulating. So I don't think that we will come across with such clauses much in the permissionless system. And that's why I think for permissionless system, rather than the system level, we are trying to, you know, solve the issue at the system level. Maybe it might be a better approach to deal with this applicable law issue at transaction level. I hope that answers the question.
Wonderful. Maybe if we turn to Amy, maybe you can pick up on, oh, sorry.
Can I just say something about
yes, please.
Other question? I don't think I can answer that conclusively, and I'm not even sure if it's the last one that was speaking about party liability and smart contracts. I'm not sure if that is actually about liability and tort, because I mean, there will, in any scenario, there will be cases that fall outside of the scope and reality of governing any kind of crypto network purely through its own means, because there will always be an outside world that interacts, if only maliciously, with its members, and be it only by stealing assets that I mean, there may be ways to, in fact, provide some kind of protection against that through the means of the network itself, but there will be other cases where this is not possible and where parties very much want to rely on the courts. And this is actually something we're also seeing, that there's quite a number of cases already in courts in first instance decisions where people who were tricked out of their crypto assets actually went to the courts in order to try to recover those assets. So there will always be an outside world that we need to take into account. And I think that kind of links to something that Florian said about the distinction between contract and tort, and that there are, especially in these kind of cases, parties that may be kind of linked to a network, but not contractually in the proper sense. And I think this is actually something that we should think about, and that the private international law of tort needs to come to terms with, that there may be situations where we have sets of rules that apply to a wide range of people, but they are not law in the PIL sense of the word. They are a level below that. We also see the same phenomenon on social media platforms, which enforce their own sets of rules very effectively, but those rules are very distinct from state law. But this does not mean that state law should be blind to them. I think there need to be ways in which they can be taken into account when assessing liability under national laws. And I think PIL can help, for instance, through Article 17 of the Rome II regulation, which some of you may be aware, which speaks about safety rules in place in the place of the tort, which don't apply as law, but apply nonetheless, are to be taken into account by the courts, as they are part of the regulatory framework. And I think this is something that needs to be explored more when it comes to those systems which we kind of believe are self-governing, but obviously are not in a way that we don't need the courts anymore. But we need to be think about the interfaces between the national and international legal framework and the self-governance of those networks.
Thank you. Amy, any thoughts?
I'm happy to take a stab at the question regarding public interest. I mean, I think certainly the fact that conferences such as this and the work being done by various international organizations and legislators, regulatory authorities around the world is in itself a reflection of the public interest in acting on these matters. Certainly individual parties are coming before courts around the world, in England and Wales in particular, insolvency proceedings around the world. I think this is all a clear sign that certainly we can't ignore this trend any further as a kind of passing fancy or a sort of trendy thing of the moment. And even if we're not specifically, you know, if we're crypto skeptics, perhaps, or we don't really believe in decentralized ledger technology, I think this move towards delocalization is actually part of a much wider trend, which Tobias mentioned sort of began with the online sphere. It's been certainly exacerbated by decentralization. But I think common issues and themes can be said in things like metaverse, digital twins, etc. The same essential questions of finding an appropriate connecting factor to a single law is going to arise. So whether or not we think crypto is a thing to take seriously or not, I think that the issues that it's brought to light are certainly going to be relevant going forward.
Thank you, Amy. I see that we only have 3 minutes left. I can skip my conclusion of all of your thoughts and just leave you to perhaps answer the questions that we put out there to all of your colleagues, and give you 2 of the 3 minutes left.
Oh no, I don't think it's all right. Yeah,
You're fine. Okay,
yeah,
all right. Well then,
yeah.
Wonderful. Then if I can just summarize, I'll summarize in the next 2 minutes what's been said. Of the points that were raised, it seems that Yüksel, Ripley, and Heindler argue that a choice of law, rule, or instrument on crypto assets should only deal with a few specific questions which are not sufficiently addressed by the existing choice of law, rules, or instruments. Held and Lutzi both argue in favor of a process that looks to the most appropriate connecting factor and legal system, and both seem to suggest a focus on the parties, either looking to who has control over the assets, as Held suggests, for the general law of property, or for Lutzi, who writes about tort, looking to the locus actus for certain cases. Finally, it's unclear whether any of the experts anticipate a PIL one-stop shop in the form of a single Hague Convention. While none of the experts are excluding this possibility, it seems less likely for property matters, given the scope for future substantive sui generis regimes, removing Omni territorial assets from the scope of general property law. On behalf of our panel, I would like to reiterate our thanks to the HCCH for the kind invitation and the impeccable organization of this very timely conference. Thank you.